Hello everyone. Welcome to HM Commerce Education. This is CA Manichandana. So hope you all are doing good, great, studying. Yes. Okay. So yeah, we were doing Companies Act 2013, right? So even before we start off with today's class, let's just revise whatever we have learnt in our previous class. Okay, so we had started with the features of the company. You all know the features of the company. I just made you read, right? I think I've explained 3 and 2 are left out. So we'll just again revise those 5 features of the company. Very important, children, with respect to your examination. The features of the company is very important. We'll just name the 5 features of the company, the main features of the company. First one being the separate legal entity. Then we learned about artificial legal person. We also learned about the common seal. And 2 are left out. That is, one is perpetual succession and the other one being limited liability of the members. Clear? Now let's just revise, okay? Separate legal entity. Separate legal entity. I think this is visible, right? Yeah. Okay. Fine. Separate legal entity. What is this? I told you that company is itself a person, an artificial person, and it has a unique character, and it is separate legal entity in the eyes of law. It is a separate entity in the eyes of law. It can do anything we as human beings, what all we can do, the company also can do all of those things. Yes, we have learned all of it. Examples: it can own property, it can have bank accounts, it can incur liabilities. Yes, it can enter into contracts. Yes or no? Then it is at law a person which is different from the owners or the subscribers to the memorandum of association of a company. Yes or no? Then even members can contract with the company, acquire right against it, incur liability to it. I've explained you, even members, say for example, if I am a member, I can what? Enter into contact with the company, acquire right against it. Say for example, I supply goods to the company. And I become the creditor in the books of the company. Yes or no? Now, do I have a right against the company? Yes or no? Even though I am a member, I can still enter into contract with the company. I have entered into contract to, say for example, supply certain goods with the company. Now, company has bought goods from me. It has to pay back to me. Now I am the creditor in the books of the company. Now, do I have the right against the company or not to get the money from the company? So I have a right against the company. Similarly, incur liability to it. If say for example, if I am a debtor in the books of the company, if I am a debtor in the books of the company, I have to pay to the company. Yes or no? Yes. All of this I've explained. It's just the revision. Okay, next, a company is capable of owning, enjoying, and disposing of property in its own name. It can own, it can dispose. Dispose meaning sell the property in its own name. Yes or no? The capital or assets, whichever we as members get into the company, that is not the property of the members. It is the property of the company. It is in its own name, not in the name of the members. Next, a member does not even have an insurable interest in the property of the company. Case law, which is the case law which we learned here, Macaura versus Northern Assurance Company Limited. What happened in this particular case? Mr. M, that is Macaura, was almost holding all of the shares in the company, and what happened? But what did he do? He took insurance of the stock. Here it was timber of the stock basically. So he took the insurance in his name and not in the name of the company, because he thought that because he held almost all the shares of the company, it wouldn't make a difference. But what happened when the timber got fire, when the factory got fire and all the timber was lost, he went and applied for insurance. What did the insurance company tell? No, I will not pay you. Now he went to the court. What happened? In whose favor did the decision come? It came in the favor of the insurance company, yes or no? Do you remember the case law? Yes, held the insurance company was not liable to pay, as no shareholder has any right to any item of the property which is owned by the company, That is what they're telling here. Member does not have an insurable interest in the property of the company. It is a property of the company. It is not the property of the member of the company. Getting it clear? Right? So M could not claim compensation. M could not claim compensation from the insurance company. He lost the case. Right? Which was the second feature which we learned, that was artificial legal person. Yes, artificial legal person. It is created by law. It is created by law. The company is born by the process of law. Yes, yes or no? Do you remember? Yes, ma'am. Next, further, the company being a separate legal entity, all of whatever is there, it's the same thing they've written. Yes, even members can contact with the company, etc., etc. Yes, next point here. It can sue and be sued in its own name. It can sue and be sued in its, meaning it can file a case against others. The company, in the name of the company, it can file case against others, and the others can file case against the company. It is possible. Yes or no? Yes, ma'am. It can do everything. Fine. Then it is a legal person in its own sense. Yes, correct. As the company is a artificial person, it can act only through, it alone cannot go and enter into contracts. It alone cannot go and buy property. Yes or no? So it needs the help of some human agency. Who are these human agencies which work for the company? They are called the directors or the management of the company. These are called the directors. Directors are they agents of the company or the agents of the members of the company? Ma'am. What is it? The directors are the agents of the company, and they are not the agents of the members of the company. Clear? Yes. Next, we also studied about common seal. Yes or no? What is a common seal? It is the official signature of the company. Official signature of the company. Is it mandatory? No, ma'am. It is not mandatory. It is made optional. It is made optional by the Companies Amendment Act 2015. Correct? Yes or no? Yes. Now, if the company has a common seal, it can use so. Yes. Yes, it can use, if it opts to have a common seal, yes, it can authenticate the documents using the common seal. Now, if the company opts to not have a common seal, then any of the two directors, or what is it, or by a director and a company secretary, if the company has a company secretary. You know who all are company secretaries. Yes, right. So these were the three features of the company which we learned, and today we are going to do the rest. Okay, the fourth one being perpetual succession. The fourth one being perpetual succession. Okay, wait. Okay, fine. Perpetual succession. Children, what do you mean by this? What do you mean by perpetual succession? It is nothing but you the company exists forever, continuous existence, something like continuous existence, meaning, see, you know that a company is a person altogether different from the members. It has its own individual it has its own identity. It is separate legal entity. It has nothing to do with the members of the company. Now tell me, say for example, a company has 3 or 4 members. For example, let's take, there are 3 members in a company. Now what happens? All the members die. Do you think the company will also die? Do you think the company will also die? It's a question. Do you think the company will also die? No. The answer is no. Why, ma'am? Why? Because the company is born, company came into existence by law. Yes, by law, by the act of law. Now, if the company has to wound up, meaning if the company has to liquidate or if the company has to close, that happens only by the grounds which is specified by the act. It is only possible by the grounds specified by the act. If all the members of the company die, even then the company exists. It continues forever. It continues forever until it is wound up by the grounds which are specified by the act. Getting it? The members may come, the members may go. Today I can be the member, tomorrow other person might step into my place. Today I am the member. After few years, maybe I am not the member of the company, but still the company as a company exists forever until it is wound up by the grounds which are specified by the Act, meaning the Companies Act. Getting it? You would have seen, you would have come across many companies, say for example, LIC, Tata, Reliance, for example here, Bombay Dyeing. See, it says since 1879. Since 1879. Do you think the founders of this company are still alive? Do you think the founders of, say, for example, Bombay Dyeing, are they still alive? No, ma'am. No, yes or no? But still, do you find Bombay Dyeing products in the market? Is there a company called Bombay Dyeing now, right now in 2024? Yes, ma'am. So what does this mean? Bombay Dyeing is there since 1879. The members might have come, they would have gone, they would have died. People, members would have changed. The company, the ownership of the company. Today it might be with me. Tomorrow it might be with a different person. But still, the company goes on forever until it is wound up by the Act. Getting it clear? Now, come, I'll just give you a small example. Okay, fine. Okay, see this. Yeah, okay. Perpetual succession. Let's just read. Okay, perpetual succession. Fine. What do you mean by perpetual succession? It's nothing but continuous existence. The company will be in existence even with the members, or even if the members come and go. The members might die, members might change. See, members may die, members may change, but the company goes on till it is wound up as per the Act, meaning the Companies Act. Getting it? See, shares of the company may change hands indefinitely. Shares of the company, shares meaning shares. Shares meaning if you own the shares of the company, these shares might change hands indefinitely, but that does not affect the existence of the company. Clear? It might change indefinitely, meaning n number of times. The shares of the company may change hands n number of times, but that does not affect the existence of the company. Fine. Since a company is an artificial person, I told you, because it is a artificial person, it has a separate legal entity. It is an entity on its own. So it is created by law. It can only be destroyed by law. Since a company is an artificial person which came into existence by law, it can be destroyed only by the process of law. Clear? Clear? Very simple. Okay. Now let's just see a small example. See, there is a company called ABC Limited. There is a company called ABC Limited, formed by, say, for example, these four owners. These are the four owners of the company, or the members of the company. Now see what happened. All of these four members of the company, they were friends, and after the entire work, the business, everything, the peak season of the business came to an end. They all planned for a holiday. So this company called ABC Limited had only four members. It had only four. 1, 2, 3, 4. These were the people who owned the ABC Limited. Getting it? Now, what did these people do? They went on a trip. They went on a holiday. See what kind of trips they are taking. All very dangerous trips. See the road? Yes. What would have happened? Guess. Accident. What happened? Accident. Accident happened. Ayo papa. Ayo papa. All of the four members, all of the four owners of the company ABC Limited, what happened? All of them rest in peace. All of them died. Now tell me, you all know the answer. What happens to the company? What happens to the company? See here, all these four owners of the company are deathed, China. All of the four members of the company, the owners of the company, are deathed, China. But what happened to the company? What happened to the company? It is not deathed, Bangaram. Right? Yes. Yes or no? See, company continues until it is wound up by the Act. Getting it? All the members in photo. All the members, see, 1, 2, 3, 4. 1, 2, 3, 4. All of them in photo. But company in photo, na? Company in photo? No, company not in photo. The company will continue. Continuous existence. Perpetual succession. Now is it clear? will the existence of the company be affected by the death or insolvency of the members of the company? Tell me whether the existence of the company is affected by the death of the members or insolvency of the members. No. Yes or no? No. Fine. Clear? Right. Now the concept is clear. The company continues whether or not the members are alive or they are dead. Getting it? It is a separate legal entity altogether. It has its own existence. It is an artificial person which is created by law and it can be destroyed only by law. Okay, getting it? Clear? This particular point, is it clear? Now let's go to the book to read whatever is there. Fine. See, now it's very easy for you all to understand. Okay, fine. Come back to the book, page number 449. Okay. Members may die or change. Members may die or they might change. Could be for any reason. Okay. But the company goes on, but the company goes on till it is wound up on the ground specified by the act. Clear? Yes. Yes, ma'am. The shares of the company may change hands indefinitely, but that does not affect the existence of the company, even though the shares of the company change hands in number of times. Today I hold the shares, tomorrow some other person holds the shares, the day after tomorrow, meaning over the period of time the shares might change hands indefinitely, but that does not affect the existence of the company. Clear? Yes. Since a company is an artificial person which is created by law, its existence came, the company came into existence by law. Yes, alone, by law alone can bring an end to its life. Since a company is an artificial created by law, law alone can bring an end to its life. Clear? Its existence is not affected. Is it affected by the death of the members? Is it affected by the insolvency of the members? No, ma'am. No. Its existence is not affected by the death or insolvency of the members of the company. Clear? Everyone? Okay, there's one example. Let's just read it here. Okay, many companies in India are in existence for over 100 years. You know a lot of companies which are in existence for so many years. Yes or no? This is possible only due to the fact that the company has perpetual existence. That is only possible because of this particular feature of the company that is called perpetual existence. Clear? Yes, ma'am. Okay. There, one more example. Okay. There was a company which has 7 members and all of them died in an aircraft. In our example, how did they die? They died because of some accident, not aircraft accident, but road accident. That's all difference. Okay. But they all died. Yes, ma'am, they all died. Despite this, the company still exists, unlike partnership form of business. Partnership, will do it later after Companies Act, probably Indian Contract Act or Partnership Act. Let's see, let me decide, or maybe if you all ask me, whichever you all want, we can do that first. Okay, either Companies Act, sorry, after we finish Companies Act, we can either start with Indian Contract Act or with Partnership Act. Okay, fine. You all can tell me, okay, which you want. Do you want Partnership or Indian Contract Act? Let's see. Okay, fine. You can message me, children. I will reply to you all personally. You can do it on the on our app, HM Commerce Education. I'll reply you. Okay, fine. Or you can also comment in the comment box. Okay, fine. Right. Let's start with the next feature, that is limited liability. Before starting, children, I'll just make you write. Okay, this is, just write down limited liability of members Getting it? What is it? Limited liability of members. Okay. Ma'am, why did you make us write something like this? What is this? Limited liability of members. See, children, we are reading what? We are studying features of the company. We are studying features of the company. In that, one feature is limited liability. We are talking about limited liability. Now, is this limited liability of the company or is it of the member? The question is the limited liability of the company or of a member? The answer is the limited liability is of members. Limited liability is of members, and the liability is not limited with respect to the company. The company's liability is not limited, it is unlimited. Okay, the liability of the members of the company is limited. So this is one of the very important feature of the company, and many people start a company keeping this reason in mind, because it protects the personal asset of the members. See, what do you mean by this particular feature? What is the meaning of this particular feature is, see, when a company is formed and there are shareholders or there are members or the owners of the company, their liability is limited. Their liability is limited. Meaning what? Meaning the personal assets of the members or the owners of the company will not be attached. The personal assets, meaning if, say for example, if I am the member of a particular company, I'm talking about company, I'm not talking about partnership firm. I'm talking about company. We are studying what? We are studying Companies Act. Yes or no? So if I am a member of a company, if I am a member of a company, and if the company makes default, in making payments to its debts, to its creditors, or whichever debt it has taken. Say for example, a company has taken a loan. Say for example, there is a company. Wait. Okay. Say for example, there is a company name, any company. Say, oh, okay. There is a company ABC Limited. There is a company ABC Limited. It owes to its creditors, or whatever debts it has made, or loans, or whatever. Say for example, rupees 10 lakhs. Rupees how much? Rupees 10 lakhs. This is the debt. Debt of whom? Debt of company. It is a debt of the company. Yes, now there are also the members of the company. Members of the company. Say, who are the members of the company? Say for example, P, Q, R, enough. 3 members. Okay. Who are these? P, Q, R. Who are these? These are members of the company. Okay. Now, this amount of rupees 10 lakh, which is the debt, whose debt is it? Whose debt is this rupees 10 lakh? It is debt of the company. Yes or no? Is it the debt of the company or the members of the company? Is this rupees 10 lakh a debt of the company or that of the members of the company? Children, think. Company is a separate entity. It is different from the members. It is different from the members of the company. Company is different. Members are different. They both are not the same. Yes or no? Company is different. Members are different. Now this particular debt, is it of the company or members of the company? Children, if you're thinking it is members of the company, it is the debt of the members of the company, you're completely wrong. Yes, you have not understood anything. You have not understood the previous features also. Yes, those who are thinking, those who are actually getting it, yes, that it is the debt of the company. This rupees 10 lakh is the debt of the company. You all are right. Why? Because obviously this is the debt of the company. The company is a separate entity altogether. Yes, it has made loans from party XYZ, from third parties, or it has purchased goods, it has not paid them. Now it is a duty of this company ABC Limited to honor this payment. Yes or no? It is a duty or responsibility of this ABC Limited to honor this rupees 10 lakh. Is it the duty of the member? Say for example, this P is me. Say for example, this is a member. This P is me. Say for example, this is money. Okay, money and Q and R. These are the members of the company. Now, this ABC Limited could not honor that rupees 10 lakh to that particular creditor or from whomever the loan is being taken. Now, that particular, this say for example, creditor, this one is creditor, say for example, H. For example, H. Now, that person, because he did not recover this rupees 10 lakh from ABC Limited, he cannot come take my car and go. Getting it? Car is my personal asset. I have only invested in the company. I have only purchased shares in the company. Say for example, money. I or yourself, you can imagine yourself. Say for example, you have invested in a company ABC Limited and that company has not made payment to its creditor. Now that creditor cannot come and take away your car or your jewelry or your house and go. Clear? Getting it? That is to mean that the personal assets of the members of the company cannot be attached for the dues of the company. For the defaults made by the company, we as members are not, our personal assets are not attached. This is a very important feature, and it is a very distinguishing feature from that of a partnership form of entity. In case of a company form of an entity, this particular feature is of great importance. Okay, but when it comes to partnership, if the partnership firm takes any loan and it is not able to repay that particular loan, the partners will have to pay it back to the creditors or from whomever the loan is taken from their assets, from their personal assets, because it is there. Obviously, they are the partners, they own that particular firm, and if the firm cannot pay the loan to the creditor or whomever the loan is taken, obviously the personal assets of the partners will be attached, and they can take away their car, they can take away their jewelry, they can take away their anything, getting it, to repay the loan. That is partnership. But in case of company, company is different, members are different. Company's assets is company's assets only. Members' assets is different from the assets of the company. Getting it? Clear? So now will the members of the company, do they have to pay rupees 10 lakh to the creditors? Do they have to sell off their personal assets and pay the due to the creditors or from whomever the loan is taken? The answer is no, children. The answer is no. Okay, what is the maximum amount that the members will have to pay in case of, if asked for? If asked for, what is the maximum amount that the members of the company has to pay? Now come, let's read the book. Okay, one second. Fine, okay. What did I tell you? Limited liability, is that of a company or is that of a member? Limited liability is of a member. This one is clear? Yes? Yes, ma'am. So you should be very careful in your examination. Whenever you write, you'll have to write the limited liability is that of a member and not of a company. You cannot tell limited liability is of a company. Clear? This one is clear? Okay. Now what is the maximum amount that you can that the company can ask from the members? What is the maximum amount that the company can ask from its members? Okay, that depends on the type of the company. Now that depends on the type of the company. If the company is limited by shares, now the liability of members is limited to the extent of the nominal value of shares held by them. It is limited to the extent of the nominal value of shares held by them. What do you mean by the nominal value? The face value of the shares held by them. See, let's take an example. See, nominal value is rupees 10. The company has called and the shareholder has paid a value of rupees 8. The company has called and obviously whatever the company has called, the shareholders have paid, that is rupees 8. So what is the maximum amount that the company can call from its members? What is the maximum amount that the company can call from its members? Is only rupees 2. Is only rupees 2. Say let's consider an example. I'll just give you one more small example so that this will be even more clear. Okay, say the same, let's take that previous example only. Money, I have say 10,000 shares. I have 10,000 shares. Okay, now the value of one share is rupees 10. Yes or no? The value of one share is rupees 10. Yes, so that is 1 lakh. Yeah, 1 lakh. Yes or no? Now, how much is the called and paid up? Called and paid up is rupees 8. Rupees 8. Yes or no? So 10,000 shares into rupees 8, that is 80,000. 80,000. Now, how much is the maximum amount the company can call from this particular shareholder? From this particular shareholder, what is the maximum amount that the company can call? That is 10,000 shares into rupees 2. This is the uncalled portion of the share. Yes, the face value of the share is rupees 10. Called and paid up is rupees 8. What is the uncalled amount? That is the uncalled amount, that is rupees 2. That is the maximum amount which it can now call from its shareholder, from this particular shareholder, that is money, who holds 10,000 shares. This is the maximum amount it can call. Understanding? Say for example, one more company where one second, one more example. Okay, let's consider one more company in which the shareholders have paid the entire 10 rupees. The entire 10 rupees. One second. Okay, fine. There's one more company in which nominal value is 10, called and paid up is rupees 10. It is rupees 10, not 8. Okay, now what is the maximum amount that can be called from the members? It is rupees 0. Yes, because why? The entire nominal value has been called and paid up by the members. See, so see, the liability of members is limited to the extent of the nominal value of shares held by them. Now they have paid the entire nominal value, entire rupees 10. Now what is the maximum amount that can be called from members? Rupees 0. Rupees 0. So whatever, I being a shareholder, I being the member of that particular company, I am liable only and only to the amount of share, only to the amount of nominal value of the shares held by me in that particular company. That's all. That's all. My personal assets will not be attached. My personal assets will not be attached, and the debts of the company will not become the debts of the members of the company. Clear? Getting it? This point is very clear. Yes? Okay. Now, if that is done, let's come to the next type of company, which is company limited by shares. Yes? Okay. So first one, sorry, this is not company limited by shares, children. This has to be changed. This is company limited by guarantee. This is company limited by guarantee. This is company limited by shares. Okay. This is company limited by guarantee, and this is unlimited company. This is unlimited company. Okay. Fine. Okay. In case of company limited by shares, liability of members is limited to the extent of the nominal value of the shares held by them. Say example you have seen. Okay. Now company limited by guarantee. In this, ma'am, let's read. The members are liable to the extent of the amount guaranteed by them. To the extent of amount guaranteed by them. Here it is not limited by shares. There are no shares. This is company limited by guarantee. Here what happens, ma'am? The members will be liable only to the amount of the guaranteed amount. Whatever the amount the members have guaranteed at the time of incorporation of the company, that is the only amount which they will be asked to pay. Ma'am, when this is a major difference, children. We will see company limited by shares, company limited by guarantee, company unlimited company. We will do it. It will come again in your further maybe in another 2 or 3 days. We'll be doing that as well. There we'll do it little more detail. I've almost explained it to you here, but the differences you will get to know. But see here, See, this amount, whatever the amount which the member has guaranteed, that can be called only during liquidation of the company. Liquidation meaning winding up. Whenever the company is being wound up, only at that point of time, the amount whichever is guaranteed by the member during incorporation can be called for. Getting it? Whatever. Say, for example, if you are the member of a guarantee company limited by guarantee, whatever amount you have guaranteed at the time of incorporation, that, say for example, you guarantee an amount of rupees 5 lakhs. You guarantee an amount of rupees 5 lakh to the company. Now, the company can ask that rupees 5 lakh from you only and only if the company goes into liquidation. So, if the company is running the business efficiently, if it is not being wound up, if it does not go into liquidation, that amount of 5 lakh, the company cannot ask from the member. The company cannot ask from the member. But when it comes to company limited by shares, it is not necessary that this amount of rupees 2 needs to be asked only during liquidation. No, it can be asked at any time whenever the company is doing business or when the company goes into liquidation. It can be asked any time. Yes, but when it is a company limited by guarantee, the amount which the member has guaranteed to pay, that can be asked only and only when the company goes into liquidation. Else it cannot be asked from the member. Getting it? Getting this? This is clear. Okay, next comes unlimited company. Ma'am, what is this? See, liability of its members is unlimited. There's nothing to tell because it's an unlimited company. The name itself suggests it is unlimited. So, liability of members is also unlimited. Getting it? Clear? Yes, ma'am. Now, let's read. Now, if the concept is clear, let's start reading from your books. Page number 449. Okay, page number 449. Okay. Limited liability of members. The liability of a member depends upon the kind of company in which he is a member. Depends upon what? Depends upon the kind of company in which he is a member. We all know that company is a separate legal entity which is distinct from its members. Yes or no? This though we know very well. See, thus now in case of a limited liability company, they're talking about what? In case of limited liability company. Okay, see, the debts of the company in totality do not become the debts of the shareholders. Yes or no? Obviously, it is a separate legal entity which is distinct from its members. Now, whatever the debts which the company makes, those are the debts of that particular company, and those debts are not the debts of the members of the company. We members are different from the company. Company is different and we as members are different. Getting it? So the debts whichever the company makes are the debts of the company and not of the members of the company. Clear? Okay, now let's see. In case of a limited liability company, the liability of the members of the company is limited to the extent of the nominal value of shares held by them. It is limited to the extent of the nominal value of shares held by them, and the personal assets of the members cannot be attached. They cannot take away my belongings. Yes, whatever I have invested in the company, say for example, I give rupees 1 lakh. Say I have invested rupees 1 lakh in that particular company. My liability is limited to that particular 1 lakh. If I have paid the entire 1 lakh, then the company cannot ask even a single rupee from its member. Say for example, in that rupees 1 lakh, I have paid only 60,000 or say for example 50,000. Now the balance amount it can ask from the members of the company in case of limited liability company limited by shares. Getting it? Yes, ma'am. In no case can the shareholders be asked to pay anything more than the unpaid value of their shares. I told you, whatever amount is unpaid. In our example, it was 2 rupees. Yes, that was the unpaid, uncalled capital or unpaid capital. Yes or no? That is the maximum amount the company can ask from the shareholders. If not even a single rupee in excess to that, the company can ask from its shareholder. If the company has paid all, if the members have paid their entire value of the nominal value of their shares, then not even a single rupee can be asked from the members of the company. Getting it? Yes. Yes, ma'am. Now, in case of a company limited by guarantee, members are liable only to the extent of amount which they have guaranteed, whichever they have, whatever the amount they have guaranteed, say for example 1 lakh, 5 lakh, 10 lakh, 10 crore, whatever it is, whatever the amount they have guaranteed, only that amount it can be, the company can ask, and only when the company goes into liquidation, only and only when the company goes into liquidation. However, if it is an unlimited company, then what will happen? The name itself suggests unlimited. Also, the liability of members is also unlimited. Liability of members is also unlimited. Clear? Yes. Understood the concept? Limited liability. This is one of the most important one. All of the 5 features are very important. This is very important. Ma'am, this is not important. This is also important. Ma'am, this is not important. Oh, you children, this is very, very important. Yes. Ma'am, let me come to artificial legal person. That is not important. That is also important. Ma'am, common seal. Children, that is also important. So, whatever is there in your book, everything is important. Whatever is there in your book, everything is important. This is not your university exams or your PU exams or any other normal exams wherein you can do a selective study. Not possible. In CA, that if you have decided that you will study on a selective basis, say for example, this particular topic has come 10 times in the exam, so I will study this topic. The next topic, it has not come. Say, this is also very important. If some other topic, if it has not come in the exam, I will not study that particular topic. You know what will happen? You know what will happen? This is bound to happen. The topics which you have left without studying, those are the topics which will appear in the examination. This, children, I'm telling you, with my personal experience and the experience of my students. See, I have come online now. That does not mean I have not interacted with students. That does not mean I don't have students. What I'm trying to tell you is I have seen students who do a selective study and who fail in their examinations. See, it's very, 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 very important in this particular examination. Keep it your CA foundation, keep it your CA intermediate or CA final. This rule will apply from CA foundation to CA final. That is, you should not leave any single topic whichever is there in your book. This is the first and foremost rule for you to clear your exam. You cannot do a selective study. You cannot do a selective study. Every topic is important, every subject is important, every single line is important. Getting it? You can write it on your own, that is different thing, but you cannot leave any topic. You cannot leave any topic. You have to study all of the topics. You have to give equal weightage. You have to give equal importance to every single topic in your book. If it is there in your book, there is every chance that it can come in your examination. Getting it? Yes. So before we conclude today's session, let's just revise whatever we have studied. It's just 2 features, the other 2 features which we have done. Okay, let me just conclude it, okay, by a small revision. Okay, perpetual succession. Okay, first let us revise all the 5 features of the company. What are they? The first one being separate legal entity, artificial legal person, common seal. Now today, perpetual succession and limited liability of the members of the company. Now, perpetual succession. What does perpetual succession mean? It means that the company goes on forever, continuous existence. That is, even if the members die or even if the members change, that does not affect the company. The company is an artificial legal person and it is born by law. It comes into existence by the provisions of the act or law, and it will be destroyed only by the act or the provisions of law. Getting it? Clear? Next, the shares of the company may change hands indefinitely, but that does not affect the existence of the company, right? Since this we learned. Yes, this I just said now. Since a company is an artificial person created by law alone can bring an end to its life. Its existence is not affected by the death or insolvency of its members. Okay, clear? Yes, ma'am. Limited liability of members. Limited liability of members depends upon the kind of company in which that particular member is a member. Okay, now fine. In case of a limited liability company limited by shares, the maximum amount that the member has to pay is the nominal amount of the nominal value of the shares of the company. In no case the shareholders can be asked to pay anything more than the unpaid capital. If the member has paid the entire value of the nominal value of the shares, and there is nothing which is to be called up, then not even a single rupee can be asked from that particular member. Getting it? Yes, ma'am. In case of a company limited by guarantee, what is the amount? Whatever the amount they have guaranteed, that is the amount that can be asked from that particular member, and that can be asked only during liquidation of the company. The company cannot ask when it is doing business. It can be asked only when it goes into liquidation. But when it comes to company limited by shares, the amount can be asked even during the company, which is whenever it is doing business or whenever it goes into liquidation. Getting it? Clear? Next, however, if it is an unlimited company, the liability of the members is unlimited. It is unlimited. Getting it? Clear? That's all. Are you revising? Yes. Are you feeling it easy? Companies Act? Yes or no? It's easy, right? The concepts are so easy. Okay. Now, children, before leaving, I just want you all to write a memory technique here, just with next to the features of the company. So there are 5 features of the company. It's very easy for you all to remember if you know the concept. If you have understood the concept, if you have been with me together for these 2 classes, it's very easy for you to remember. You don't have to even use any memory technique to remember this. But happens sometimes in the examination, you might not be able to recollect all the 5 points. Could happen because of lack of revision or due to exam tension. So just for that, I am giving you a memory technique. Okay, just write down class. Write down class. So features of the company. Class. C being common seal. L being limited liability. A artificial legal person. Next, S separate legal entity. Last S being succession, perpetual succession. Okay. You want me to write it down? C being what? Common seal. Common seal. L limited. You could get a question in the examination asking you to write all the features of the company. So you should not make a mistake in such questions. Children, you should never make mistakes. Whichever, if the questions are straightforward, you should feel very happy. Okay, you should not lose even a single mark when you get such questions. Okay, then A, artificial legal person. Yes. S being a separate legal entity. Separate legal entity. Last S, perpetual succession. Perpetual succession. So class C L A S and S. Okay, clear everyone? You all will remember this for your examination. You also should know what just not remembering class and just forgetting it. You should know what is there in that particular subheading. So if you are asked to write about separate legal entity, or if they give you any question based on separate legal entity, you should always know what is there inside that separate legal, what is there under that separate legal entity concept. What do you mean by what? Perpetual succession. You should know. It's not just perpetual succession. You just can't write company has perpetual succession. I've seen students. I have evaluated papers. I know how students write. They'll write what? A class. They know class. No, they'll write all 5. They'll write. See, that in that also they'll make mistakes. S they'll forget. Happens. It's not that it's not your fault, but happens due to lack of revision or because of tension of the exam. That's fine. If you forget, that is a different thing. But if you have not studied, that is a different thing altogether. You cannot write perpetual succession, and in that you cannot write perpetual succession means a company will have perpetual succession. That is, a company will go on succeeding. company has all and finally they'll write something else, and then they'll conclude, okay, so the company has perpetual succession. That thing is fine. I also see students, they'll write limited liability, because in your ICI material also there is only limited liability. They will write limited liability. The liability is limited. The company, the features of the company, no, you're all asked to write the features of the company. Limited liability is one such feature. They'll write limited liability. The liability of the company is limited. The company has only limited liability. The liability of the company is limited. So limited liability. This is one of the features. This is one of the features. That also they'll write. The limited, what is the question? To write the features of the company. Under limited liability, they'll again write, this is one of the feature of the company form of organization. This also they'll write. Do you think this is such an examination wherein whatever you write, you'll get marks? Do you think that is going to happen? No. Until and unless you're serious about CA course, please do not take up this course, because this is not what you think. This is not what you have done all these years and still you have managed to clear your examinations. No, it is not like that. This is an exam wherein you are tested and you have to prove yourself. You have to prove yourself. If you do not have that capability, if you do not ignite that capability within you to prove what you are, then you are not fit for this particular course. I'm sorry, students. Okay, so what I'm telling you all is that make sure you put in a lot of effort to study and learn whatever is done in class, and make sure you revise on a daily basis. Make sure you attend questions once you finish a particular chapter. Make sure you go through the questions. You put in all efforts from your end and leave the results to the God. Okay, He will take care. Okay, but without putting efforts, you cannot rely on God. Okay, fine. So this is it from my end. Okay, so I hope you all will revise whatever we have done in class today. Yes. Okay, so that's it for now. Bye bye, take care. Okay.